Hello and welcome to another edition or episode of QuickIP. We are talking today about trademarks, the rights, the infringements, and the remedies for infringements. As usual, we locate our points on our timeline or on our map. We've dealt with the introductory matters, talking about the definition of trademarks and the rationale for trademark protection. We've dealt with the requirements for trademark protection, talking about the mark that is capable of distinguishing one person's goods or services from those of another. We've talked about the fact that you need registration for a mark for you to enjoy trademark protection. We've said that the registrar of trademark could refuse one's application for registration, or a third party could successfully oppose one's application for trademark registration under specified grounds. And today we are in step 4, where we are dealing with the rights that trademark law confers on trademark proprietors or trademark owners, the various ways in which trademark could be infringed, and the remedies that are available when one successfully establishes that their trademark has been infringed upon. So, what are the rights that are provided upon trademark registration? Once you have successfully obtained registration of trademark, it is your mark is protected, and you are entitled to prohibit or stop others from using it in the course of trade. Of course, remember that we said that trademark law protects a particular kind of use, and that's use in the course of trade. So people are allowed to say your trademark, they are just not allowed to use it in the course of trade to maybe promote their own services or to use the trademark in the way that is exclusively reserved for you as a trademark owner. So you have the exclusive right to affix your trademark on goods, on packaging, on labels, and you have the exclusive right to use your trademark in any other way in relation to the goods for which it is registered. So this extends to granting a license to another party to use the trademark in return for payment. So that's when you do your license, another person to use your trademark, maybe in another jurisdiction, maybe in another location, or maybe it's a franchising agreement where they are using your trademark as well as other aspects of your business to run things the way you run them as well under a franchising agreement. And when you register a trademark, the duration of the protection of trademark varies from country to country. In South Africa, it's 10 years from the date of application. So you apply, and then there's all these, processes of the registrar of trademark looking at the trademark, considering your application. There's the opposition process that may happen or may not happen, depending. There might be no opposition to your trademark registration, or if there is, all these things, once they finish running through and you succeed and your trademark is registered, you start counting the duration of protection from the date of application, not from the date that you receive your certificate or from the date that the mark is finally registered. And the registration of trademark is something that can be renewed indefinitely, and each renewal of registration is 10 years. So every 10 years, you can continue to renew your trademark registration forever if you want. When is a trademark infringed? There are various ways, especially when we are focusing on South African law. A trademark could be infringed when you have a case of unauthorized use in the course of trade of a registered trademark on identical goods or services, and likely to deceive or cause confusion. So what are we saying here? If someone is using your trademark in the course of trade in relation to an identical good or goods or services, so say you have a trademark in respect of an electric kettle, for example, and another person is using a trademark that is, similar to yours or your trademark on electric kettles. And in that instance, it's likely to deceive or cause confusion, then there will be infringement. Infringement could also happen when there's, again, unauthorized use in the course of trade of a registered trademark on similar goods or services. So it doesn't have to be the exact same goods or services. It could be something that is similar, usually maybe something that is in the same class of goods. Like remember that in the first QuickIP, when we're talking about introduction to trademark law, we mentioned that trademark registration happens in classes, in different classes. And so if, and so it's not, so there's one class that could mention, footwear, mention textiles, mention clothing, mention other things. And so let's say, you have a mark that is, let's say a fashion item, that could be used in different ways. So you're talking similar goods or services, but not the exact same kind of goods or the exact same kind of service, and it's likely to deceive or cause confusion. There would be infringement. It's also possible to infringe a trademark by dilution. And what happens with dilution is that someone is using the mark in a way that sort of like blurs the difference between your mark and theirs. And then you will say that this person is diluting your mark, and that they are doing so in they are doing so in a way that blurs the distinctive character of your mark. And in that kind of environment, they are taking unfair advantage of your mark. It's also possible to infringe a mark by dilution through tarnishment. Now you're not blurring, you are actually using a mark in a way that is detrimental to the distinctive character or the reputation of a mark. So let's say I'm not going to mention any particular brand, but let's say I have a mark called TMC, for example, and then someone says is using TMC in the course of trade, but they are using it in a way that tarnishes the reputation of the TMC mark, then there could be infringement by dilution through tarnishment. It's also possible, again, when you talk of Paris Convention well-known marks, where there's unauthorized reproduction or imitation or translation of such mark. When you have any of these activities taking place, one could successfully make a case for trademark infringement. And if they are able to prove that their trademark has been infringed, they would be entitled to various remedies. And the remedies could be an interdict. That's usually the starting point for most trademark actions in court. They will first apply to court for an interdict to stop you from using the mark. And then pending the determination of the substantive suit, or even perpetually. And then they would also then maybe ask for an order to remove the infringing mark from the goods. So they are saying, you can continue selling your product, but any of your packaging or any aspect of your product that bears our mark, remove them. And the court could oblige the trademark owner with that order. Or where it's not possible to remove the infringing mark from the goods, like in a case where it's part and parcel of the goods that removing it will maybe destroy the goods, they will just say, deliver up the goods bearing such infringing marks, send it to the trademark proprietor to do whatever they want to do with it, which is usually to destroy them. It could also be that they could ask for damages, or they could ask for reasonable royalties in lieu of damages. So damages and reasonable royalties, you don't ask for them side by side. You ask for either damages or you ask for reasonable royalties. And that brings us to the end of the gist about trademark rights, infringements, and remedies. And we'll have more details in class. See you. Bye.